Hello, kia ora. Lucia here, property investment mentor and founder of the Finax Mortgages and Insurance. This is the recording of 1 hour live webinars. If you would like to join us in our next webinars and be part of the Q&A, please head to our website, luciaxiao.co.nz. I trust you will definitely learn a lot from this video. Thank you. Okay, so we might just going to get started, and I know that some of you probably haven't really actually met me before, so I'll probably just give you a quick introduction of myself, hopefully just 10 seconds, yeah. So my name is Lucia Xiao, and I am a property investment mentor, mortgage advisor, and also founder of Finax Home Loans. And if you are interested, because last year I published my book, and it's called Financial Freedom, 5 Steps in 5 Years. So if it's any of you actually interested in the book, so basically it's kind of my personal story from, living in the state house and later on build a $17 million property portfolio in a very short 5 years time. Yeah. So if it's any of you are interested on this, you can actually email us at support@luciaxiao.co.nz. Okay, so joining us today is Ping Chen. So Ping Chen is a very, very experienced lawyer, and she's also the lawyer for our former Prime Minister John Key. I don't know how much John Key is paying her, for the advice, but today we are very, very lucky to having her, with us, and give her any questions that you have. So today, Ping is going to share with us that how to avoiding, all those pitfalls, during the purchasing of properties. Yeah. So she's going to take us through the sale and purchase agreement and what to look for and how can you actually avoiding this and making sure that your money is safe. Your deposits are safe. Yeah. Ping runs a very successful law firm. And her partners is Jeff Usher, and I probably will going to just let her to actually introduce herself and the services that they can provide for you as well. Okay, thank you, Ping.
Hi everyone, my name is Ping Chen, and from PCW Law. So we are one-stop law firm. We provide the legal service like such as property, commercial, family, criminal, civil litigation, and debt collection and immigration. So we can help you with any legal problem. So you may ask, how can I do that? I'm not one woman band. We have over 10 lawyers with a wide range of legal expertise. So my partner, Jeff Usher, is he's specialized in civil litigation with 30 years experience. And we have our family lawyer, immigration lawyer, so we can help you with any legal problem. So one of our particular specialties is property law. So this is why I'm here today. So why do you need a good lawyer to get you through the whole property transaction? So now I would like to share with you the answer. So now we are going to talk about you need a good support throughout your property buying journey. A few questions you must ask your lawyer before you're engaged. The first question is, do you specialize in property law? If you don't expect a dentist to catch you or to do your surgery, why do you expect an immigration lawyer or a very good family lawyer to do your property transaction? The second question you need to ask is are you approachable? Some lawyers are too busy. Clients comments once an engagement letter signed, my lawyer disappeared. You do need to spend some time with your lawyer and tell your lawyer about yourself, about your individual circumstances, and what clauses should be included in the agreement. In order to best protect yourself, talk about this as early as possible. That will save you time when it comes to making an offer. For our convincing team, So most of our lawyers have more than 20 years legal experience. We provide multilingual and multi-legal service. We will use your language to make sure you understand the important documents, the sale and purchase agreement. So because the purchase and sale agreement was changed last year, so you need to use the right sale and purchase agreement. The most up-to-date one is ADLS version 2. So I have already put it next. This is the latest version, purchase and sale agreement. So now I'm going to talk about like common ways to purchase properties. So typically, purchaser make an offer. The vendor accepts or makes a counter offer. Our advice here is that both parties need to put a timeline. For example, this offer will be only open for acceptance until 4 p.m. on Tuesday, 23rd of June. The reason we do that is you need certainty. For example, when you find other properties you want to buy, as long as the offer is expired, you are free to make a new offer for your dreaming house. So the second way to purchase property, someone will go for auction. You make a bid. Once it is successful, you are committed to buying the property. Before you go to auction, you have to make sure you have checked everything. As once you win the auction, you do not have the opportunity to change your mind. Don't trust what you were told or even what you can see. You do need to do your own due diligence. We have a case. A client came to us to cancel the auction agreement. He was told by the real estate agent the house is not plaster clad. And he had been to the property once. And the property didn't look like a plaster house. After he won the auction, he found out it was a plaster house. Unfortunately, most of auction agreements you buy as it is. So someone may have the experience with tender. Each person makes the best offer in the sealed envelope signed by you. The vendor has a few working days, sometimes 5 working days, to choose the best offer, or vendor can reject all the offers. So now I would like to talk a little bit about a backup offer. For example, the existing agreement is subject to finance and the lien conditions within 10 working days. Some vendors do not want to wait for that long, 10 working days. Vendors want to include a backup condition, such as if the vendor receives an unconditional offer, vendor will give the purchaser 2 working days to announce unconditional. If the purchaser fails to go unconditional, the first agreement is canceled. The purchaser wants to have certainty. The vendor wants to have the ability to cancel the existing agreement. You can see the conflict here. This is why one lawyer cannot act for both parties, purchaser and vendor. So next, we are going to talk about conditions. So your sale and purchase agreement can include conditions such as a finance. Finance condition means you either need to have pre-approval or the agreement needs to be conditional on you obtaining finance within a certain period. So before we use this ADLS version 10 purchase and sale agreement, a lot of purchasers use this condition to cancel the agreement. Now it is very hard to use this condition because of like the vendor has the right to ask the purchaser to provide sufficient evidence to prove the finance is failed. So we recommend, if you put conditions, you need to just like put maybe like, solicitor's approval or due diligence. So LIM condition, LIM actually is Land Information Memorandum. It is a file that includes all the information held about a particular property. LIM report will tell you if there are any significant issues with the land, including important considerations, whether or not the land is flooding, whether or not Code of Compliance Certificate, CCC, is issued for such property, whether the building is historical and unable to be demolished. All of these things are not something you can identify when you inspect the property by yourself. Building report. So building report will identify issues or potential issues with the building. For example, if it is leaky building or doesn't comply with the building code. So the next condition is getting more and more important. It's called a mass test, because the manufacture and the use of mass has continued to increase. Once the house is contaminated with drugs, the owner's obligation is to decontaminate to meet the health and safety standards. It is very costly and complicated. It would be a disaster for the first home buyer. So I strongly recommend you to do mass test. So the title requisition, we're going to talk about this later. The above are obvious conditions. You can easily find them as they are on the front page. You can see that is, we highlighted. So, but there are lots of other conditions in fine print, too small for you to read. This is a good test for your eyesight. However, all conditions are important. For example, we just mentioned about title requisition. So the most expensive mistakes, you possibly could make is like sending unconditional agreement without seeking, advice from your lawyer. Also, just I mentioned before, relying on finance condition to get out of the agreement. In the past, it was easy, but now it has become more and more difficult. We do have some, precedents for, such case. If you want to be able to easily exist an agreement, make sure there is a proper due diligence clause. I know, the one juror wouldn't like to accept, the agreement with lots of conditions. So if you want to be more attractive or you want to make your offer more attractive, you do need to spend some time to check all the conditions carefully. And then you probably can make a cash offer, unconditional offer. So now I'm going to talk about the title. Actually, title is very important because of, the value of lands increase a lot. Not you buy a property, not for the building, the house, actually it's for the, the increased value of the land. So the most common types of title are, for example, fee simple. Owner has full ownership and control everything over the property. So this is a common form of ownership. But I would like to talk a little bit more about cross-lease title. So cross-lease title means like together all the properties jointly own the whole parcel of land. Each leases their part of the lands from the others. It is important to ensure that what is on the site matches the flat plan. So before you buy the property, cross-lease title property, you need to do some investigation about the relationship between the neighbors. Why? Having a good relationship with other owners is important because any changes an owner make to the flat externally must be consented by the owners of the other flats. Depending on the wording of the lease, cross-lease, the lease documents is very important. Even quite minor alterations, such as concreting your loan or internal variations. I have even seen cross lease that do not allot pets. If the neighbors are difficult to deal with, you will find later that putting on, for example, a deck on the property, you are extremely hard to get a written consent from your neighbor. For cross lease title, you have your exclusive use area. But you also need to be familiar with your and your neighbor's obligations in respect of common area, such as shared driveways. Even you need to be familiar with contributions to the maintenance of driveways. For my client, if they buy cross-lease title property, I normally invite them to my office to check the flat plan and the layout of the property. We do that together with our client, because no lawyer will visit the property to check whether or not the layout, shape, and dimensions of the flats are correctly recorded on the title plan. If not, the title is defective. For example, if a connecting garage is not on the flat plan, correcting such a defect is expensive and time-consuming, up to 6 to 9 months. As a surveyor must take measurements of the property and issue a new title plan, which also requires a written consent from owners of other flats. Sometimes you have to pay a heavy sum, lots of money for the neighbors to consent to the existing structure. Then, after you receive such consents, you have to pay your lawyer to go to links to register a new title for you. Another potentially complicated forms of title is uni-title. So this is why sometimes, like if you ask, for the price for buying a property, the uni-title property normally costs more, because we do need to check a lot more, documents such as pre-contract statement. We need to find out whether or not there are issues such as leaky issues or any ongoing litigations against this property. We also need to check meeting minutes and the body corporate rules carefully. If you're dog lovers, you have to let your lawyer check carefully whether or not pets are allowed. So it is very important, you understand those terms, conditions, and titles before you make an offer. So now we're going to talk about, you have already made an offer, unconditional offer, the vendor has accepted it. So now you have an unconditional binding agreement, but you cannot settle. So normally, if you have already got, agreement, so you cannot settle for whatever reason. So vendor normally, will instruct a lawyer to serve you a settlement notice to give you 12 working days to settle. If you fail to do so, the vendor can keep the deposit and sue you for the damages, or they can take you to court to try to force you to settle. This is called specific performance. If we are your lawyer, we will transfer your case from our property team to our dispute resolution team. Our litigators can argue strongly for your case. If your lawyer is only one man, it might be difficult at this time, as law is all about debate. So when you choose a lawyer, what is the first question you ask? Normally, it is how much is your legal fee? May I advise you to also ask a lawyer that what services will be included in this price? For example, if you choose us, we always provide a written report to our client, which will show you clearly any legal issues you must be aware of from the agreement. Because the report is in writing, your lawyer is accountable for the advice. If you only get the advice orally, for example, you ask your lawyer to check the lien report or check the builder report or check the title, your lawyer call you, advise you over the phone. So anything happens in the future, your lawyer will say, I have already told you. And you say you never received such advice or you never understood such advice. So you will not have any evidence. It is very difficult to hold your lawyer accountable, and you will have to bear the losses by yourself. For example, when we do a title search, the instruments registered on the title are also very, very important. But most of you may not notice it is only one line on the title. But if you search it, it might be hundreds of pages long. Last year, we did a title search. One easement was from 1880s with the old English handwriting. This easement gives the neighbor and his horse the right to cross the land. So your subdivision plans may fail because of such easement. You want to, for example, have a building in the middle of land, but because the easement, the neighbor's horse can cross that land. So if your purpose to purchase such property is to do subdivision, you fail. So I'm glad when we did that easement search, most of lawyers in our firm are local Kiwis, as I would have difficulties reading those old-fashioned handwritten English. So why it is so important? Let me give you another example. So a few years ago in South Auckland, some properties have covenant which limit the purchaser to be first home buyer and owner occupier. The loan was approved by the bank for such covenant. Breach the covenant by renting the property. It was no longer an owner occupier. So the bank later withdrew the loan. So the purchaser has to repay the mortgage in full immediately. So now you might realize the price is important, but the service from your lawyer is even more important. So choose the right lawyer to help you. So that is very important. So if you want to just like ask us our legal services and price, you can contact us. So later I will show you our contact details. So now I would like to share some helpful tips. So the purchaser only has one right to do final inspection. So the final inspection actually is to go there to find out whether or not the chattels are under the workable conditions, or whether, the property is still at the same conditions when you made an offer. I just normally talk with our client. I say like, the settlement date is more like, the wedding day. You can't tell your bride saying like, you have to lose 10 kilo and then I'll marry you. So you have to marry as, she is. The same principle applies here. So we recommend you to do it 2 or 3 days before the settlement date. If you find something wrong, there is still time for the vendor to fix it. But you inspect too early, further issues may rise after your inspection. So if something goes wrong, you want to withhold part of the purchase price, you must give notice at least 1 working day before settlement. Otherwise, you have to settle in full and take action later to recover. For example, one of the window is broken, or, the door is broken. So you want to withhold, for example, $1,000 until the one door fix it. If the one door doesn't fix it by a certain date, you can go ahead to spend the money on the repairs. But all of these need to be sent. The request need to be sent to the one door's lawyer on the settlement, 1 day before the settlement date. So after final inspection, you cannot refuse to settle for minor issues. You have to settle, but make it clear without prejudice to your rights to seek the remedy later. So another thing I want to, share with the first home buyer is that if you want to withdraw KiwiSaver, to withdraw funds from KiwiSaver, so application need to be, made ASAP, because such application sometimes take up to 20 working days. You need to contact your KiwiSaver to get a form and also a letter to indicate how much you may be eligible to withdraw. Then we can help you through this application. So now it's almost half an hour. So hopefully so far you still enjoy my Chinglish, and it give you some useful tips for buying your first home. So we are a team actually, with expertise to protect and grow your wealth. So if you need any help, so you can contact us. And my name is Ping Chen, and I'm from PCW Law. So,
thank you, Ping. I think we got a question here. So if you click on the chat, you can see the question there. Yeah. So Sean is asking, what if, for example, 1 out of 3 owners denied to pay towards common area maintenance? I'm not so sure whether it's talking about a cross lease or
title. So for uni title, it's easy. Normally the body corporate, so you pay annual fees, the body corporate will cover that. So you do need to talk with the manager of the body corporate. So if the cross lease title, so you do need to check the lease carefully, because sometimes there are like dispute resolution procedures. You need to go through mediation, arbitration, those processes. So, my advice is to let your lawyer check the lease properly and advise you about the dispute resolution. If they cannot resolve it, come to talk with us.
But would it be more expensive, because obviously people cannot always feel talk to the lawyer, it seems like going to costing quite a bit. Yeah.
So this is why always go back to the property lawyer who settled that property for you, because they do have the file. So they can easily pick up the lease. So my concern is that sometimes, our clients is kind of like purchase and sell. So when we sell the property, they use different lawyers. And then the purchaser's lawyer do the requisition of the title, they found out actually there are some problems. Or even when they purchase a property, they haven't received such legal advice. So normally it's not costly. If you go back to the property lawyer who settled your property, they should have file notes and stuff, they can easily tell you what happened when they, there's the lease and the requirements for the dispute. Yeah.
Okay. So that's good. Yeah. So we got another question from James. Yeah. So regarding final inspection example about broken window, what if that was broken during initial open homes? At what point does defects become eligible for remedy and repairs, and after going unconditional?
Okay. So if the open home, you have already find out the window is broken, you need to add a clause in the agreement saying pre the settlement, these windows need to be replaced. So make it essential clause. So if you don't risk issue before you made an offer. So you have to settle as it is.
Oh, right. Okay. Right. So basically that as long as when you make an offer, you actually asking to repair it, they will repair it. Otherwise you just settle as it is. Yeah.
Like I notice this, window is broken. So please make sure this is replaced or fixed before the settlement. Yeah.
Yeah. Okay. Actually, I have another question. Was once I was settling a property, and then on settlement day, because obviously I done a final inspection a day before, and then on settlement day, what we found is the vendor actually also leaving some stuff in the garage, and then they're going to pick up another day or something. But is it something that because obviously I didn't borrow to actually, having a drama of that, just a kind of small issue, but. Is it quite common? Like, the vendor still leaving something behind and.
So we're talking about the terms of this agreement. It's like, the vacant position need to be provided to the purchaser. This is a requirement of the purchase agreement, right? But sometimes we are human beings, right? We want to help each other. That is the case. But here, I would like to draw your attention to, because our firm is a one-stop firm. We do a lot of like drug-related cases. Sometimes, the parcels, the packages, who knows? So you do to, notify the other side of lawyer. Sometimes I always ask my client to bring their phone, take a photo, and then just write back to the lawyer saying like, your clients failed to provide vacant position by leaving the things, right? We request this need to be taken away by certain time, and this is the evidence for you. If anything goes wrong in the future, so you have such, strong evidence show you are not owner of this stuff. So you shouldn't be charged for example, possession of the drugs.
But does it mean that I also in the position to asking for the penalty because they couldn't give me the vacant possession if I really wanted to? Yeah.
My answer is yes. You are. But actually, the journey for you to pursue your right is probably more costly. So what you can do is that you can take the photo and later go to the tribunal, pay like $40 or $50, and then to get it done. It is cheaper than you just let your lawyer to argue this case for you. Because normally we provide a fixed price for conveyance matters. You know our price, right? If we sell a property under 1 million, our fixed fee is 800 plus GST plus disbursements. So if you go for any dispute resolutions, so we'll charge hourly rate.
So that's not worth it because a day might be only just $200, $300 penalty, and then what's the point? Yeah. Okay. I think that's probably not worth your energy. Yeah. But like you said, take a photo just in case that because we don't know what's in those contents. Yeah. Just like to protect yourself. Yeah. Okay. All right. So we got another question from Sashin. Purchasers are also using building report as negotiation tools once the sales and purchase agreement is signed. I think that's very common. Yeah. If vendor then does not agree the full discount price which purchaser is asking, can vendor back out of sales agreement? I believe so. Yeah.
Okay, so if I act for the purchaser, right? So the purchaser is not satisfied with builder report. And then we ask the vendor to fix it. So here you need to be careful because your expectation sometimes may not be met by the vendor. Even the vendor says, yes, I'm going to do that. And then before the settlement date, you check it still hasn't been done up to your standard. So sometimes the purchaser will ask for deduction from the purchase price, saying like, you just like, for example, the purchase price is 1 million, saying like, I will pay you 999 and then I will do this by myself. So if you ask for, the vendor to fix it, they have the right to say, no, I don't do anything. I do not want to do anything about this. And then the agreement might be in the end. Yeah. If you really like this property, you really want to buy it, so you need to be careful when you just raise issues about like builder report.
So that's kind of like a counter offer anyway. And if they don't agree, that basically their offer is no longer existed. Yeah, the previous offer is no longer existed. If you're actually counting it back. Yeah, okay, cool. Thank you. Yeah. All right. We got another question from Matt. So what is building line restriction in title and how to check?
Okay.
And we've seen this quite often. Yeah.
So actually, we do have that plan, normally the second page of the title, right? So we do need to check that carefully. Sometimes the actual line is different from the line. So the accurate way is to get a surveyor to check it, and then the restriction line. Otherwise, so it has to be the plan from the title.
I think sometimes also they have a year there, and sometimes it no longer exists or something, and the lawyer can always go back and then just say that's actually no longer valid or something.
The procedure is that we normally ask the one-door lawyer to make a comments, but sometimes you can't rely on their comments. So it's better for us to do our own due diligence because it is important for us.
Okay. Yeah. Okay. So is it like you just do your title check or something like through your system?
Yes, the title search. Normally we go to LIN's land title office. So we not only check, the restricted line. Sometimes there are details recordings about that. But give you example. So West of Auckland used to have a fair, just like they fair all the documents. So you don't have such recourse. But if you want to do something that is very important for you, you do need to, to check with the professionals to get the right answer for you. Yeah.
Okay. I don't know if that answer your question, Matt. Yeah. All right. We got another question from James. Yeah. Mm-hmm. So if you buy a property with current tenants, do they become yours? I have seen properties where tenants refuse to leave. Is there a risk you take on? I think that depends on vacant or, yeah. Okay. I'll let you, yeah.
This is a very good question. So the first page, the front page of your agreement. So there is like whether or not there's a vacant position. So if that, part has been filled with the tenants' details, so of course you need to take these tenants and also make sure the bond has, the bonds need to be transferred to you during the settlement date. So this one you need to deal, the purchase lawyer need to deal with the one-door's lawyer for the bond. So, and also to just make the balance of the rent to be calculated correctly. So if without that, the tenancy details, it is assumed like it's a vacant position. So if they can't provide a vacant position, so like this is the one-door's problem. So you can refuse to settle because of like they are not in the position to settle. It's one door is not in the position to settle. So you can charge penalty.
I think it's a good idea that when you are purchasing a rental property or existing tenant there, it's better to leave it, to actually put it as a vacant possession. Because even vacant possession, if they are good tenants, you can always, having your rental manager to go back and negotiate with them and drop that another new agreement. And of course, they will still do their check. Mm-hmm. I think that's probably the best way, just always, asking for vacant possession rather than taking over the existing tenancy, because we don't really know those, how good those tenants are. Yeah. Mm-hmm. Okay. Yeah. All right. We got another question from Sean. So what if there were issues with the building that were not disclosed prior to purchase? Can you return the property?
You mean mislead this? Like, sorry, can you just clarify a little bit further about these questions?
I think there are some like building issues with the building, and then there hasn't been disclosed to you. So it might be like it's a leaky house, or there are some issue there. I'm kind of guessing it's kind of that's what Sean was talking about. Okay, so while we're waiting for Sean to clarify that, and also what do you mean returned? Because how can you return a property? Are you saying like you bought it and then you want to get a vendor to buy back, or what's that mean? Yeah. Okay, so I'm correct. Right. So yes, I think he was talking about there are some issues in terms of the building. So obviously, the vendor already know there are some issue with the building. It might be a leaky issue or something, and unfortunately, the purchaser actually purchasing it without knowing that, and also vendor didn't disclose that. Yeah. Okay. So
again, so this is if it depends on is it like you make an offer, or you just like you buy the property with that auction. So just I said, so this is purchaser's obligation to make sure you check the property carefully. So for example, this problem could be resolved if you have a builder report condition. The builder can check it for you and to identify the issues. If the builder couldn't identify the issues, there are two types of legal relationship here. So firstly, so whether or not you have been misled by one door or one door's representative, if there is, you can make a claim against them, right? So secondly, if there is problem of this building, for example, leaky, but the builder has provided you a report which couldn't identify the issue, and later you can claim against the builder for the damages.
Okay, so your suggestion is like it's better we actually get a builder report done. And not necessarily have to show in the offer. It might be like before you even, are making an offer or something, do your due diligence, beforehand or something. Yeah.
If you go for auction, you have to, just as that.
You have to do your due diligence beforehand. Yeah. And I think because we also because obviously we buy quite a lot of property. So what I found is like, if you got so many conditions there, sometimes that your offers become really unattractive, to the vendor. So I always encouraging to our customer is that do your due diligence before you even make an offer, because once you've done your due diligence, maybe you are in the position to make an unconditional offer. And what we found is like a lot of vendor, even like $50,000 less, they will rather take the unconditional offer, because if there's a condition there are always a lot of uncertainty, and then they will rather actually having the certainty, especially for people that they are in a position that, they have to sell, things like that. Yeah. Okay. Yeah. So certainly do your due diligence before that. Yeah. Something to bear in mind is like, if you actually put a builder report as a condition in the same purchase agreement, very often the lender will ask for the report. And so it sometimes might actually create a bit of issue for you, because especially for like some property might be actually it's quite a solid bone, but actually it's a bit run down, needs a bit of cosmetic repairs or something. But ended up the lender, they picked up that because you got a report, so they want it as well, and then they might decline your loan because it's a do-up property. So just bear in mind that there might be an issue there. If you actually put a builder report as a condition. Yeah. Okay. But do your due diligence before you even make an offer. All right.
Yeah, that is so we got very good experience, like to share actually.
All right. So we got Stella here. I had a very bad experience. There were a lot of rubbish left at our house, as we did not find out until after settlement, as they were kept at a place which was not easy to notice. Oh my God, what are they hiding? It's under the house. So we pay from our own pocket to remove it. So please check this as well on your final inspection. Oh, so that's kind of like so Stella is actually sharing a tip with us. It's like, do your thorough check, in terms of like, yes. Yeah. I think I had another experience was we were actually renovating the house, and then just one of the rental property, and then just couldn't believe how much rubbish under the house. The builder was pulling it all out. Yeah. So it was shocking. And I think there are some people just really terrible. Yeah. Okay. I got another question here, since we're waiting for the other questions. So this one is, one of my properties actually unit title, and at the moment, they're going to do the house insurance, because every year the body corporate had to do a house insurance. And then the body corporate, they actually decided to spend $3,500 to do a valuation in order for to get basically to get a value for the purpose of the house insurance. And my personal opinion was like, that's really stupid. Yeah. And I kind of like really, because obviously I don't know that if it's in a body corporate, whether you had the right to actually decide the value I want to insure and, and just not follow what body corporate wants you to do, or do I have to follow what body corporate? Because obviously it's additional cost for everybody. And also, I might ended up have to pay more on the house insurance because the value actually it's higher. Yeah. So what's your view? Yeah.
So, firstly, we need to check the body corporate rules. This is why when we do unit title property, we need to be very careful. So sometimes the majority of body corporate members can make the decision. Sometimes it is not. It has to be unanimous, like everyone needs to agree. So we do need to check, the body corporate rules and also even the meeting minutes. Those are very, very important documents. So each owner of the unit need to understand clearly. And also don't forget, so we own the unit title property together with body corporate. So they do have the right to make certain decisions. But because I don't know, like I have never read the documents, I cannot provide the accurate legal advice. So that your lawyer check it carefully. I think they can answer your question.
Okay. Yeah. All right. Thank you. I think I think with that one might be the majority agree and then the others had to follow. Yeah. So I guess I just had to spend the money on the insurance. Yeah. Doing the valuation and everything. Yeah. Unfortunately. Yeah.
Yeah. It's a good sign. Like, price goes up. It's easy for you to get more cashback. I mean, top ups.
Oh, yeah. Okay. That one was actually quite expensive. Unit title is probably 1.25 million. Yeah. So probably looking at some stage, I probably will change to something else like freehold, so I can do anything I like. Yeah. Because it's a school zone, so we kind of bought it for that reason. Yeah. Okay. All right. We got another question here from James. Yeah. So what is a typical time frame for settlement, and what is the fastest settlement you have ever done from unconditional day? Is it stressful? Absolutely stressful. We hate it as well. Yeah.
Yeah. Okay. Your expectation, like for settlement. So and then you make me understand, client's need. Just share with me, what is your expectation?
Yeah, James, so what is your expectation? I think we had done things like from unconditional 5 working days to settle or something. And then we were actually giving 5 working days of finance day. So pretty much that in a very short time that we had to quickly actually get the approval for the customer. But don't forget, like, it's not about us, it's also about you as well, because very often as we're waiting for so long to get all the document we needed to get the funding. Yeah.
So it depends.
Oh, it's a vendor. So it's a vendor driven. So basically if it's a vendor actually wanted to have a shorter settlement, and how short it can be.
We settle one property is like, today's unconditional and tomorrow is the settlement date. Yeah, because it depends on the resources of the firm. Like what I said, we have about 18, people working together. So we all help each other. So for any urgent case, so for example, we receive the loan we act for a developer. So we receive the loan documents on, Friday morning. So it's about 8 million loan. So the settlement is on Monday.
Oh, good on you. Yeah, that's stressful. I think you should charge customer additional money. Yeah.
We do charge urgency. That is, we do charge, but we only charge, $500 urgency. But the reason is that satisfaction is this is an old client of ours, and also obviously is a big client. So, and her comment is that you are the best lawyer we, have never been engaged. So, and also after years of service, so most of our staff it's not me to make a decision because I can't go to the office. I have to do your seminar. So all my staff are willing to go there, like to just do some extra work. So it depends on how urgent the settlement is. So nothing is impossible for us. This is our culture.
Oh dear, hear that? Yeah. sometimes I feel quite sorry for the lawyer because you only charge customer on hourly rate, but the result it can be different because it might be had to taking like other lawyer like 10 days. You probably get it done in half an hour. So it's actually quite unfair. Like you're charging the hourly rate, yeah. So it's not, you can't really charging them by the result, yeah.
Yeah. Can I just share a little bit about like appreciation and also a value of a firm? So appreciation is that, since PCW law was established, we have never, spent any money in marketing and advertisement. So most of our clients, I have to say over 95%, like our clients from word of mouth. So we look after each other. And also the loyalty of our clients, just make us feel it is worthy to work over time or, more time to look after their need. Because I believe this developer, she doesn't want to get such urgent, settlements. And she has to do that because, as you see, the finance providers need to check a lot of documents, and it's just unfortunately things happens like this. We all need to work as a team together with our client to make things happen. This is our, value of the firm. And also, we want to help.
Very good. Very good. Yeah. Thank you, Ping. All right. We got another question here is from Darin. What is involved with having a property changed from cross lease to freehold? Actually, myself has been through that. Yeah. But I let Ping to cover that. Yeah.
Okay. So number one, for cross lease title, so we do need to get the surveyor to just understand, the structure. And then, so we do need to make sure all the owners of the properties agree. You have a written consent from each other. And then the next step, so the surveyor is going to provide a plan, a title plan. So the lawyer can, get this plan to go to land title office to register new title. So we have an expert named Donald Crosby who's specializing in the subdivision and also changing variations to titles. So maybe next time we can invite her to give you more specific comments.
Okay. Yeah. Thank you. Actually, it's a quite a bit involved because it's a resource concern that you are after, and whether or not you want to actually get a town planner involved, and also possibility. I think council probably wants you to actually upgrade their underground services. So I think that easily costing us additional $15,000. Just actually had to repair the stormwater and things like that. So, but it was you and the other party actually, I think it was two or three people, and if you all agree, because I think the hardest one is probably getting agreement from the other cross lease owner. If they don't want to do it, you probably just can't do it. Yeah.
If you don't obtain the written consent. And also sometimes you can go to the court. To get the court order. So Jeff has done a couple of this type of cases. But we do need to assess the case individually.
Are you saying if it's the other party didn't want to go ahead, you can still forcing them to go to actually change the cross lease to a freehold?
Circumstances for the public interest and stuff like that. So we did get court order to do that.
Oh, that's interesting. Yeah. So Lorraine was asking, was it depend on the site? Yes, certainly, because they had to make sure that you got a separate, separate underground services. Yeah. Okay, we got a question from Stella. Mm-hmm. So I would like to know if I'm selling a property and buying one, is it practical to go for auction? And how to make it work? What if I won the auction, but my old house is still not sold? That's more like my question. Is that the question for me? Yeah, I don't know. So I can answer that. It's kind of like obviously it's better talk to us and see whether you are in a position to actually because I don't know whether you buy more expensive one, you need to borrow more money, or they are very similar value or things like that. So obviously you need to, it's understand that whether with the new property and after you sell the other old one, that are you in a position having the enough money? Do you need to borrow more money and things like that? So getting the funding sorted, that's important. And usually you might want to have a longer settlement. So just in order allow you to have a time to sell your property. Because if not, otherwise, there's like a bridging loans available. I don't know if there's anything Ping would like to add on. Yeah.
So yeah, I think you answer most of the questions because you covered it. It's all about the finance, right? So you already bought one, but you probably couldn't sell this. I mean, it happens like a few weeks ago. So actually we act for the purchaser. The one door desperately want to sell the property because one door has purchased another property. Why when our client announced that as a finance is not satisfied. So, and also like the one door's family got some, personal things happened, like it's really sad, but again, so when our purchaser want to cancel the agreement, announce finance is not satisfied, they, argue strongly against that. And they try to ask our clients to just see all type of the strong evidence to show why your finances failed. Yeah. Good job. So eventually the agreement is canceled and our clients go for another property too. And they just their principle is that if you don't buy our property, you say that, your finance is not satisfied. You cannot buy any properties. So we argue strongly against that. We say that we can't afford your property because this is this price, but we can afford another property because this is, 200K less than your property. Yeah. So gain a little bit of money for the, dispute, but it is worthy, because they try to hold our clients for such, agreement. Yeah. So we need to be careful, but because you don't want to just create yourself extra trouble when you actually to fulfill your beautiful dream, like to buy a first home and, your dreaming house. You just want everything is peaceful, as smoothly as possible, right? So this is why. So when we make an offer, we just as just Lucy said, first step, we need to check everything properly if you want to make a cash offer, unconditional offer. Make sure your lawyer has checked the title, the lien report, everything for you. And also the builder has inspected the buildings. And you're confident, to make an offer. Or you put the conditions. If you don't have time or you don't want to waste the money, you have to make sure, for example, the finance condition is pre-approved and by the bank, and then you are going to spend money for builder report. So you have to make sure just you put enough conditions to protect your interest.
Yeah. Okay. All right. We got a message from Stella. So, I think there's one to share the tip. Yeah. So hi James, KiwiSaver first home withdrawal is not hard as long as you meet the requirement. Approach your KiwiSaver provider for a letter of estimate and form. Your lawyer can help you with the withdrawal process. Good luck. Yeah. Okay. I got another question. I just gonna come to my mind is the overseas. People on the work permit or, people might be on the residency, but they are kind of not qualified for buying the existing property. So what's the because that's kind of actually getting the lawyer involved now. Say a client and then their partner has got a New Zealand citizen, but themselves actually on the work permit, or they are not qualified to buy property. So can they buy property here? My understanding is they can, but I think you have to have a bit of process, isn't it? Yeah.
You're right. So we do need to have strong evidence to prove that there are kind of de facto relationship. It is very interesting. So New Zealand law actually regulates that. So from the tax, point of view, so you have to stay in New Zealand for 183 days to make yourself a permanent resident, right? And for from immigration law point of view, you have to stay under the same roof for at least 12 months. You make yourself as a partner, de facto partner. So although you are a married couple, for example, husband, wife, but one person live in China, the other person live in New Zealand. So from like immigration point of view, you're probably not like de facto partner. So this is why, as you said, 100% right. So we do need to provide strong evidence to show that these couple are still together in a genuine relationship. They are like partner, or they are the actual spouse. So, and then we can just go for that, husband, wife, or de facto partner to purchase a property, although one party who holds a work visa.
Oh, okay. So basically, like you had to actually get the approval from the OIO, is it? Yeah. Yeah. Okay. All right. I think we've covered all the questions. Yeah. I wonder have we got any more questions, or are you still typing? Yeah. So Ping, do you have anything else that you want to add on?
Yeah, so I think buying a property is the most expensive investment for our life. So we do need to be careful. And also so for example, finance, right? Just you talk about the stress sometimes is all from money. So no matter like you want to change your crosses title into a freehold, as long as you have sufficient funds, you can do that, right? All sorts of way to help you. Again, so how much money you plan to spend is very important. So my advice is always like, you do need to look after yourself by talking with professionals. Step one, for example, they need to come to talk to you. So how can I resolve my finance? What is the best budget for me to make, the offer for the first home, right? What is the best way to help me to achieve my goal? And then you come to talk with me. And, what's a safe way and also cost-effective way to buy my dreaming home? So make sure you spend some time with professionals that will save your time and your money, and especially your energy.
Oh, that's good. Yeah, very good. Thank you, Ping. So actually in my next workshop, which is coming out in 2 weeks' time, I actually put the link there, that, Eventbrite link that you can actually get a ticket from. And we actually talk about how to buy property and how to buy the right property. It's very important because as you will know, buying a property is actually experience. It's expensive experience. Yeah. So we want to make sure that you are actually able to actually buy the right ones, and you are able to actually build your assets and create your wealth, and you are able to retire earlier and doing things that you enjoy. So there's a link there actually on top of the chat box there. And so I hope to see you there in 2 weeks' time.
Okay, thank you. Okay, thank you.
And thank you, Ping. Yeah, thank you. Yeah, bye.